Okay, good afternoon, ladies and gentlemen. We're going to go on the record here in Franklin Circuit Court for a pretrial conference in Council for Better Education versus Johnson, number 21 CI 461. And we had previously set the hearing on the plaintiff's motion for injunctive relief for this time, and the parties notified the court that I guess the plaintiffs have agreed to withdraw that at this time and to agree to an expedited briefing schedule on the merits, so we could hopefully move forward toward getting the case resolved and addressing it on the merits. So I had some questions about the briefing schedule and just about what our best method is to fully address the merits and to make sure that we've got an adequate record here in the trial court for any appellate review. And those of you all who practice here on a regular basis know that I view that as kind of one of our important functions here, is to make sure that we do have an adequate record for appellate review. And these are very important questions that I think really demand that we do our utmost to make sure that all the pertinent facts and law are in the record for appellate review. So I have some concerns about maybe deciding the case simply on an expedited briefing schedule. So that's what I wanted to put out on the table for discussion today. And let's begin with maybe having counsel all enter your appearances for the record, so I know who we've got on the call and who you represent. So we can start with Ms. Snell for the plaintiffs. Who is muted now, so we can't hear you.
Okay, is that better?
That's better, yeah.
Okay, well, I represent the Council for Better Education, the Warren County Board of Education, and Franklin Independent Board of Education.
And if you want, Ms. Snell, if you want to go ahead and just introduce your co-counsel and let me know who's going to be speaking for you all, maybe that will expedite things. So.
Well, my partner, Mitzi Wyrick, is on here with us, and she also represents CBE and the school districts. And then here for the parent plaintiffs are Eric Harrington and Kristen Holler. So I believe those are the only, and Jeff Walther is also on, and I believe those are the people I see representing the plaintiff parents. And okay. I will be speaking, but Eric also might chime in if I forget something. Yeah,
that's fine. Okay, so that kind of covers the plaintiff side of the table, and so we've got, it looks like Mr. Thacker on behalf of the Attorney General's office in the Commonwealth, correct?
Yes, Your Honor, and I believe Aaron Stiletto from our office is also on. So I'll be addressing the recording unless I forget something and Aaron has to jump in.
Sure, and anybody's welcome to chime in, but I guess each side ought to have kind of one person take the lead. So, but we'll welcome any observations or contributions that any of the council have to make. So, Mr. Thacker and Mr. Stiletto for the Attorney General's office. I see Mr. Thomas here, I guess on behalf of Secretary Johnson and
Commissioner Miller. Good afternoon, Your Honor. Brian Thomas. Alongside me are Robert Long, Bethany Rice, and Jen Stossberg on behalf of both the Secretary and the Commissioner.
Okay. Okay. And we have some intervening defendants. Mr. Metzger, I guess you're the local counsel, right? But if you want to introduce who we have for the intervening defendant parents.
Yes, Your Honor, thank you. We do represent the intervener defendant parents, Ms. McNeary and Ms. Deaton. I have with me today Joshua House and Ben Field, and I believe Mr. House is going to be taking the lead for us.
Okay. All right, I think that pretty much covers it. Did we miss anybody? Okay, well, so we have, you all have tendered a proposed briefing schedule, and normally courts are eager to sign anything that's submitted with the caption "agreed order." So, and that's usually my practice too, but I did want to just express some concerns that I would like to get some input from you all about, moving forward, because, in reading the briefs for the withdrawn motion for injunctive relief, it's obvious to the court that we've got at least two extremely diametrically opposed theories of interpretation of this statute. And I will say, in just looking at the statute itself, it seems to me that to some degree, we're kind of in uncharted territory here in Kentucky in terms of this kind of a program. It appears to me to be, somewhat complicated. I'm not quite sure about the mechanics of how this statute is going to be implemented and how it's going to impact public education in Kentucky. And, we have, an argument from the plaintiffs that it's going to that it runs counter to the requirements of the Kentucky Constitution in terms of both its provisions on education and to some degree its provisions on taxation. And on the other hand, we've got arguments from the Commonwealth and the interveners that kind of take the position that this tax credit program really doesn't implicate the Constitution at all, in the sense that it's totally privately funded and there's no state involvement in it other than to approve the account granting organizations and the allocation of tax credits, but essentially it's all private money. And so from that standpoint, I will just say that it seems to me like that there is a significant chance that after reading and digesting the briefs on the merits, that I may have, questions about whether there are disputed issues of material fact. And I guess what I'm trying to avoid, I know this case is important to everybody, and I think it's important to everybody to get an expedited decision because of the impact it will potentially have on both on the public schools and on the many students and families who are hoping to take advantage of these funding opportunities. And, from that standpoint, I guess I'm a little bit concerned that maybe it might be more, it seems to me like it might be more efficient for us to plan from the outset to have a hearing in this case at which the court could consider, relevant testimony, both factual testimony and expert testimony, and again, create a better record for appellate review that would, give rise, I think, to a better understanding on my part, and I would hope on part of the appellate courts as well, as to the practical implications of how this statute will work, how it will be administered, what its impact will be on the funding of common schools, what its impact is, if any, on the SEEK program, which is the primary mechanism for the legislature funding the common schools. And again, we have diametrically opposed views about this. I think, the plaintiff's indicating that it's going to create a serious problem, and the defendants and intervening defendants arguing that it doesn't implicate the SEEK funding at all. And again, it just seems to me like it would be helpful to create a record in which we have some factual testimony and expert testimony about the educational impact of the statute, about about how it's going to be implemented, and various factors that would help put the bare bones of the statute into better context to evaluate the constitutional questions that are presented here. So I just throw that out for your consideration, and I would welcome your observations about it, or suggestions.
Judge, we expected that you might have that view, and it's completely understandable. It might be a wise course to perhaps brief it under a schedule that you like. Maybe, we discussed it and we submitted it, and then at that point, either go ahead and schedule a hearing now after the briefing, or wait until the court has had an opportunity to look at it and then set a hearing and give direction on exactly what concerns the court and what the court would like to hear.
Your Honor, Christopher Thacker for the Commonwealth.
Yeah, Mr. Thacker.
I do just want to make single that we do have a great concern about the timing. The current legislation has a 5-year period, including this tax year being one of them. And so, based on the affidavit filed by on behalf of the cabinet last week, we know that the procedure of implementing the program and getting the regs and the forms out, and then the period to review applications, it looks like it'll be October before you could have at the earliest that the first of the applications for the tax credit be approved. And that's I'm not that seems reasonable and realistic. But one thing we would very much want to avoid is anything that would risk pushing it later in this tax year.
We're already halfway through the tax year, right?
That's right. I mean, October gives time. People who really want to contribute to these programs are going to have time, but not a lot. So I think, and so to my mind, I'm certainly not adverse to perhaps looking at a trial date, but I do think that, well, first of all, I'm not sure what factual issue would actually be dispositive from what I've read. And I don't know that any of us can say that until we've perhaps had the cross motion summary judgment. That may resolve everything, and there may be nothing.
Yeah.
At a minimum, it would narrow what would be left for a factual resolution, I think, substantially. So I would like to keep an expedited briefing schedule and get as early a hearing as we can on the dispositive motions. Mm-hmm. Whether you do that at the same time that we, set other deadlines for a potential trial, I'm open to that. But again, I don't, and I open up the other parties. Again, from my view, I'm not sure exactly. There are certainly disagreements, but I don't know how many are actually about actual facts today.
Yeah.
But so that's my 2 cents. And I'm really concerned about trying to get a resolution by that October timeframe, so we don't delay the effectiveness and if it is appropriate and constitutional, we want people to be able to take advantage of it, of the 25 million for this year.
Mhm. Okay. And again, one of the things I guess factually that I'm just looking for some help on is that I'm not sure I understand at all how this program will work, from a practical standpoint. And I guess I'm a big fan of testimony from witnesses and directing cross-examination to to shed light on those kinds of questions, because I think without that, it's kind of hard for a court to understand how this program is actually going to work. And again, I don't know, if there is anyone who can explain it to the court. I would hope there is, because we're in the process of setting up a program now, and I guess that we're kind of moving the discussion toward the responsibility, I guess, of the Department of Revenue and Secretary Johnson. So maybe I can call on Mr. Thomas to shed some light on that in terms of, is there someone who can really explain how this program is going to work, how the department is going to implement it, and the approval process for the AGOs, and the allocation of tax credits, and what all is involved with that, and how it will actually work on the ground, I guess, is something that I'm again, I'm hesitant to issue rulings on the law if I don't understand the mechanics of how the program actually works. So maybe Mr. Thomas can offer some, shed some light on what the Revenue Department's understanding is.
Sure, Your Honor, and we did file an affidavit in the record in this case to try to help the parties understand the timing at the Department of Revenue, and of course the department is currently building this program, and so looking at the statutory structure, looking at the the rest of the revenue statutes and regulations, and trying to harmonize those to find a way forward here. So I don't know if today
it's a work in progress, right?
That's exactly
Yeah.
right. I think we're still building towards that.
Yeah.
That being said, given some time to prepare, we may be able to, at least give you an educated guess on exactly what the program would look like.
Yeah. Okay. Well, again, just as an example of the kinds of questions that I've got right now, having read your briefs on the preliminary injunction, and I don't know how this is going to work. So I want somebody to educate me about how it's going to work in practical impact. The plaintiffs have indicated, well, this is unconstitutional because it's going to allocate public funds to private schools, and those arguments, and the defendants have to some degree responded, well, this isn't just a program to benefit private schools, it's to benefit all low and middle income families, and not just those who are in private schools. So public school students are eligible for obtaining these grants if they need additional tutoring, if they need computers, if they need various things that will help them to enhance their experience in the public schools. But that again raises questions in my mind. Number one, I don't know if that's true or not, or if it's going to be interpreted that way by the Revenue Department. But I also wonder if that is true. We still have a question about disparities of funding in terms of educational opportunities for all children in the state. So, to the extent that is true, it seems to me like it may raise a question about whether this $25 million in tax credit is going to be used in a way that is going to exacerbate the inequality of funding and educational opportunity and provide, maybe much needed help and relief for children from homes where the parents are sophisticated and understand how to seek government, assistance or private assistance that's funded by this tax credit and can go through the application process and get funding to help their kid who's in public school or private school. But the kids maybe who are from families that don't know how to navigate through that kind of system, or who are homeless, or who don't have the skills necessary to go through the process, may end up being that much further behind. Those are the kinds of things that concern me. And again, I don't see how we're going to have an adequate record to address those just by briefing. So, I guess in some sense, I'm going to ask Ms. Snell and her colleagues, how are we going to get a record developed that's going to address those questions and that's going to give the court the opportunity to ask questions? And what's your all's suggestion for how we do that?
Judge, I think obviously whatever would help you the most. I mean, if you would want to have more developed briefing and then have a hearing to address the questions the court has articulated, that might make more sense, or schedule a hearing before the briefing. I know Mr. Thacker has expressed his concern for expedited hearing, and the plaintiffs agree and share that concern. And I guess not, I don't want to say the cart and the horse, but it's like, what do you want to do first or second?
Mm-hmm. Well, I mean, let me ask you, do you all have an expert witness who can testify about the impact of this legislation on the SEEK program, or on the funding of public school districts, or on the overall system?
We have not yet retained an expert. I mean, I know that there's a lot of information about this, I'm sure, but we had been viewing our position as a constitutional challenge on the face of the statute. But now that we hear the court's concern, we can, move in that direction if that makes sense.
Okay. Well, it doesn't appear to me that any of the questions posed by this are exactly, self-evident. And, it seems to me like this is a very complex statutory mechanism that's been put in place. And, so I think it's going to be difficult for the court to judge the merits of the case in a vacuum. And that's kind of where we are right now, as far as I can tell. So
Your Honor,
that's a concern I've got. Yeah, Mr. Thacker.
Yes, Your Honor. Sorry for interrupting there. I do think Ms. Snell's reference to the sort of facial character of the challenge is helpful.
Yeah.
I do think, at least conceptually, that I think we can certainly look at the text of the statute and text of the Constitution and get a legal conclusion as to whether on its face these constitutional provisions that have been cited are actually on the face of the constitutional language and the case law interpreting it, whether there's a facial problem. It may be that the court could answer no to that, and then it may be that we're for instance, the issue of effect on funding. We know next year won't have any effect on funding because you actually have a budget passed that increases by, I think, about 4% SEEK funding for the next school year over this one at the same time this first 25 million is made available. Now, it may be that, and it's going to, if there were, as a theoretical matter, we would reject the idea that that's ever going to affect funding. The General Assembly is going to retain its duty to adequately fund the schools, and we'll do that through a separate appropriation, the budget bill from this statute. But even accepting, that the argument's made, it seems to me that that's an argument that would have to develop over the course of years, at least over the, we'd have to see another budget year or something like that. So I'm not sure. So there may be down the road an as applied challenge that someone may want to make. But I think that's, I don't know that that's ripe yet, or that we could develop a record to really, people can bring experts to, I guess, add to the speculation that you already have. But
Right.
I'm really not confident that within the next, anytime within the next 6 months, we're going to have enough new facts on how the statute plays out to do the kind of as applied analysis that may or may not arise in the coming years.
Your Honor, if I may, Your Honor.
Yes, Mr. Harrington.
Eric Harrington, perhaps I have a suggested path forward here. It seems that that the court has questions both of law and of fact. The questions of law of how the statutory regime is going to actually operate, and then there are some questions of fact that, in our mind, there are sort of two issues I think that are relevant here. One is, are they even really disputed? And then two is, if they are disputed, are they material facts? So one path potentially forward here that kind of responds to all of our concerns is we could push the briefing schedule somewhat, provide time for the parties to reach stipulated facts and identify what are the disputed facts, have our cross motions for summary judgment, and then of course Your Honor decides whether these disputes of fact are material or not. And to the extent they are material, then we would go to a bench trial and decide those disputed material facts. If and each of the standards of review for summary judgment, one side doesn't prevail.
Mm-hmm. Okay. Well, that's I think that's worth considering. Maybe just adjusting. We could think about adjusting the briefing schedule so that we would start out with the parties reaching an agreement on a stipulation as to the relevant facts that their motions raise. And if there's not a stipulation on that, then we would be able to make adjustments and provide for a hearing at which those factual issues and I think potentially expert opinions could be developed at a hearing. So.
Your Honor, I wanted to say that we don't oppose what Mr. Harrington just proposed. I think Mr. Thacker hit the nail on the head in the sense of that really what needs to be done is narrowing some issues. I think that we would be just a little hesitant to push briefing all too far back, because I think what we haven't had in this case, which we normally would by the time you get to dispositive briefing, is some sort of briefing on the merits of the claims in general, right? Either on the pleadings or, in a motion to dismiss posture. And we haven't had that to sort of narrow some of the legal claims. So I would just be hesitant about pushing us too far into the case when, our position, as I said at the last hearing, was that I don't think they've stated a claim for which relief can be granted based on the face of the complaint. And it's, only if this court, of course, believes that they have, do I think we need to get into some of those factual issues.
Well, and of course, there's been substantial briefing, I guess, that touches on the merits of all of these arguments in the briefing on the injunctive relief. So, I mean, it's not like, we're completely in the dark about what those arguments are going to be. So I would think we can have fairly expedited briefing. And again, I would hope we can get the case, and I don't see any reason why we can't get the case in a posture, to have all of that complete before the October date when the revenue cabinet has indicated is the earliest time at which they would be in a position to take action on the AGO approval. So, and I don't know, but again, that seems to me to be kind of a key date. That's the kind of date that will have some immediate, some real world consequences. And until that happens, there's a little bit of time to plow through these things. So, but again, those are all things I'm a little bit concerned about. And then, when I look at the record that we've got so far and some of the arguments that have been advanced regarding, there certainly is appears to be an argument about the validity of the classifications that the legislature has drawn in this legislation. And I will tell you that's something that it seems to me like there ought to be some factual information in the record as to, why the classification was drawn concerning the counties of a population of 90,000 or more. Again, we don't have anything in the record on that now, but it seems to me like that's relevant. I certainly think it's something that needs to be addressed, and I'm not quite sure why, if this program is is valid and appropriate and constitutional. I have to wonder why parents in Franklin County are not eligible to get the tuition assistance that parents in Davis County or Warren County or Kenton County are. There are 3 private schools in Franklin County that, I'm not quite sure I understand why they would be excluded. And I expect there are other counties in the state in the same position, but again, there's no factual information in the record about that. I think those things are going to have to be fleshed out and developed. And I guess, that's one of the reasons I'm not quite sure we can resolve all of this by just a briefing schedule and, a review of the facial constitutionality of the statute. So, again, my thought is that if we can provide for those kinds of concerns as we set a scheduling order, I would rather do that on the front end than to go through, briefing and argument and a round of summary judgment that may well not resolve the case completely. And it seems to me like it's in everybody's best interest to have the record fully completed and fleshed out as soon as possible. And if, and I'm not sure the best way to do that. So, and I have some concerns about whether that's in our haste to try to expedite a briefing schedule here, we may not, create problems in terms of having a fully developed record and addressing all those issues as quickly as possible. So, those are my concerns, and I would, again, welcome any kind of observations or inputs that you all have, because you all know the case a whole lot better than I do. I've just, begun to get an understanding of the issues you all are arguing, and you all are living with it. So,
Your Honor, at least from, the Finance Cabinet and Revenue Department's perspective, we're certainly happy to go back and either put together an additional affidavit, or, if the court deems it appropriate, offer up some other type of factual information in terms of, how we expect for the statute to be administered in the near future. But I'm not sure if
Right.
we're the appropriate party to address some of the other issues that have.
Yeah, right. Okay. Well, I think maybe at this point, what I'm inclined to do is to, for the moment, kind of put the briefing schedule on hold until we see if you all can reach a stipulation as to the relevant facts that need to be before the court to decide the initial dispositive motions. And if there is, if there's factual agreement on that, then we can move forward with an expedited briefing schedule on that. And if there's not, then we can set a hearing and provide expedited disclosures and discovery and, have a hearing relatively quickly that would flesh out any areas where there are disputed issues of material fact. And, there may not be, I don't know, but that might be one way to go. So. The proposed briefing schedule would have the briefing complete toward the end of August, is that right?
That's correct, Your Honor. August 23rd, I believe, is the deadline for replies to be filed.
Okay. Okay, well, anybody have any additional suggestions for the court on that? All right, well, let me take a look at what you all have submitted. Before I sign off on a briefing schedule, I may issue a pretrial order that will require you all to meet and confer and see if you can reach an agreement as to any stipulated facts that both parties would accept in terms of the initial round of briefs, and that might solve some of my concerns. And then we'll, again, I think we can do an expedited briefing schedule that will get the case briefed. And I think if we need to have a hearing, I don't see any reason why we couldn't have that done, prior to the October date that the Revenue Department has indicated is the earliest date at which they'll be ready to proceed with approvals of the program. And but again, I'll welcome any additional suggestions or observations, and if there are none.
Yeah, Your Honor, if I may, Your Honor, I thought the other that I think might be useful is both to identify the stipulated facts and then to identify for the court the disputed facts, and then whether they're material or not, we can,
Right.
So that might also focus.
Maybe a disagreement about
also
that
focus
as well,
on
certainly. Yeah. No, I that's a good point.
Yes.
So, okay, well, let me think about this a little bit more, and then I will get an order issued within the next day or so, and then we'll proceed forward. We'll have some kind of expedited briefing schedule. I'm going to also reserve the right to set a hearing at which I would expect the plaintiffs to be able to present some testimony that will explain to the court, the impact that they're arguing on public education in Kentucky and the common schools and the SEEK formula and the funding mechanisms, if there is any. And I understand that's a seriously disputed matter. Whether it's a matter of law or a matter of fact, I guess, is unclear to the court at this time, but I will try to get you all in order that will give you my direction as to how we need to proceed to get the record developed. And again, my only goal and concern in this is that we have a full and complete record. This is an important case. And I think we need to make sure that we've got an adequate record, both for me to make an initial decision and obviously for the appellate courts to review it. And I think I feel confident we can do that, and we can do it on a very expedited basis. But I want you all to be thinking about how to make the best record for your clients for appellate review, and how to make the best record for your clients for my review, to make sure that we fully address all these very important questions. So with that, unless anybody's got any additional suggestions, we'll and I'll open the floor. So hearing none, I'm going to go ahead and we'll recess court, and I'll get you all in order, hopefully within the next day or so, and then we'll proceed forward and hopefully move toward getting this case resolved on the merits as soon as possible. So, okay, thank you very much, and the court will stand in recess.